Good evening. This is John Milburn for Laws 12062, Alternative Dispute Resolution. We're into week 6. I do hope that you enjoyed your break. I also hope that you are well advanced in your assessment work. And indeed, I can say that some students are starting to upload their assessment already. So if you haven't started, please make a move to start in earnest now. You'll need to move quickly. The assessment is due very soon. If you're having trouble with the group, please remember, of course, this is ultimately an individual assessment. So the idea of working together is to have some collaboration, to provide some assistance. And in having a group of 3 for your audio-visual, you've got 2 people that can act as the protagonists in your dispute scenario. But you can always use someone else. And if the group arrangement isn't working, that's fine. Just move on to something else. And thank you all for joining us this evening. Tonight we're continuing in the discussions that we've had for the last couple of weeks in relation to mediation techniques generally, and we're going to talk also about negotiation techniques, conflict issues, and later in the unit, and towards the next week or the week after, we'll be talking much more law than we are at the moment, which is for the first half of the unit, very practically orientated. Now, with that in mind, I trust that people have been applying their skills in mediation, negotiation, active listening in a real live context. So over the past few weeks, I've invited you to take some of the concepts that we've been talking about and apply them in your lives. So can I ask for any feedback? Has anyone been actively listening, using hand gestures, using different body language in order to promote different types of responses, and just gauging the reaction and trying to use that effectively? Anyone been doing that? No? All right. If you have some incident which has been useful to you, some technique that you find that works in terms of your ability to act as an effective communicator and an ADR practitioner, please let us know. So for the moment, I'm going to share the screen. We're going to look at a continuation of some of the work that we've been talking about. And we got so far as to talk about participation in an ADR session. So with any luck, you can now see, again, just bear with me, that doesn't quite look right. I'm just trying to find the appropriate screen. I'll share it now. Yes, so you should see some slides. So we were up to the stage of seeing the various techniques that ADR practitioners use in dealing with ADR process. Reframing, as we know, is where we take something from a transitional stage and try to move it into a different space. So transition to the positive means encouraging something which was initially negative and trying to make it into a positive response. And usually you're taking the essence of what was said and reframing it with a forward focus in mind. Transition to the future is very much along those lines. So what we're saying here is the statement was, my daughter was such a lovely girl. I don't know why she has become so bitter. And the response, so you love your daughter and you want a caring and mutually respectful relationship with your daughter, is an example of reframing with a transition to the future. Transition to interests, always relevant for ADR practitioners, where we're trying to find the essence of the dispute and what really matters to a participant in the dispute. I cannot live this way with all that noise coming from my neighbourhood property. I can't sleep. So you like where you're living and you want to maintain your lifestyle. Transition to interests. Shared approach is where you're trying to create, if you like, a common problem or sometimes a common enemy so that you can galvanise the parties to work hopefully together to deal with a problem in a shared approach. Sometimes from a practical perspective in a mediation session, I will, for example, lay out a map or a photograph or some document in the middle of the table and encourage the parties to look at that document, that map, that photograph, and it starts to create a feeling, a dynamic, if you like, that they are sharing in the problem, sharing in hopefully the solutions as well. When it comes to making offers in a mediation session, don't underestimate the importance of making a first offer. Try to package an offer so that you are dealing very much with apples. Reassure your client, let them know that this is a process that may seem frustrating, it may seem foreign to them, and because they've typically been guarded, reluctant to provide information to the other side, distrustful of the other side, it means a dramatic shift in their thinking, and you need to reassure them that this is something which ultimately works to their advantage, we hope. So the genogram, the skills that you need in trying to identify the names of participants in a session is always important, and we talked about that's from Love Actually, and the different types of mechanisms that people, or the different interrelationships between people, and sometimes having that down in a form of a diagram is a substantial help. Now, a few different specialty processes. For example, in QCAT we have hybrid hearings, which is where we conduct a mediation at the end of a hearing. It's purely facilitative mediation technique, and it provides the parties with a last opportunity to resolve issues. Youth justice conferences, family group meetings, or court-ordered conferences for child protection matters, and parties in planning and environment issues may also have some specialties. One specialty mediation that we'll talk about later in the unit is justice mediation, and it's an opportunity for defendants who are charged with criminal offences to engage in a mediation session with the complainants, and ultimately that can provide a very good outcome for both the defendant and the complainant. All right, so I'm going to stop the share. Thank you as we worked through that. Do we have any questions about techniques in mediation practice or conciliation practice? Not so much the legal aspects, but more the theory, the practical aspects, more the aspects of how you go about conducting the session in an effective manner. No questions? All right.
I would ask, John, if possible,
yes, Nicholas?
you could share that PowerPoint that we just went through. Could you share that on Moodle with us?
Yeah, sure. I've got a feeling that a version of it, possibly a Word version, is there, but I will make sure that that is shared, and I'll put that on Moodle. So, yeah, thank you, Nicholas. All right, any questions, comments? Moodle, PowerPoint. Diane said it's in the weekly readings, perhaps. All right, thank you. Well, I'll make it nice and obvious, and I'll put it in the mediation session. So I'll put it in what mediation is week 4, I think, week 5, so I'll put it there. All right, so we're talking about practical aspects, and what we've seen that is common to, if you like, all of these disputes is a level of conflict. And I guess that's fairly obvious, but if you're going to be a good ADR practitioner, it means that you need to engage with people. You need to create that connection. You need to become their new best friend, to use the words of Professor Ashman from QCAT. In order to do that, you need to obtain a better understanding of them and to some degree them of you, but primarily it's you gaining a better understanding of them. And one way that you can effectively understand them in the context of a dispute is to understand why, in general terms, people might fall into conflict. If I suggested to you that there are 2 basic areas where people, where conflict is categorized, or how conflict can be categorized, it would be tension, emotion is one side, and then the other is poor communication. They work in tandem, don't they? If, for example, people are not in a tense emotional situation, they're likely to communicate more effectively, aren't they? Likewise, if they're having struggle communicating, it's likely to increase their level of tension and emotion. So in terms of communication, it might be that the communication is incorrect, it's miscommunication, or it's a lack of information, or there may be some impediment like language difficulty or capacity issues, all of which result in poor communication. So part of your role as an ADR practitioner is to try to identify that that is an issue. To some degree, and I mean this in a neutral sense, call it, identify it, and then attempt to resolve it. But the process of identifying the problem can sometimes take you a long way to being an effective dispute resolution practitioner in terms of resolving the issue. Tension might also be created through power imbalance, and we see this often in a domestic violence type situation or a workplace bullying type situation. So you need to be in a position where you can identify the power imbalance, call it, and I mean that in a neutral sense, and then assist the parties to diffuse it. Does anyone have any reflections on issues to do with conflict? Are there other reasons why people might be in conflict beyond, if you like, the general characteristics that I've said of tension/emotion and poor communication? Are there any other general characteristics? Okay, personalities, yeah, and that sometimes that's it. You know, people are very different, and people have different personalities. So, to try to identify the personality to deal with that is also important. All right. So, given that conflict is often, almost always, going to be part of your platform around which you're working, we need to identify how people might act in a conflict situation. I guess there are some obvious ones. People become very emotional, but they become and angry. Sometimes they become frustrated, which is very often the case. And they do things that they try to make life easier for themselves by avoiding or failing to listen, or they try to reduce uncertainty, and sometimes they try to inflict pain. Very often in a conflict situation, people will try to avoid the difficult big issue and they'll focus on little issues. Have you ever come across that? If you've witnessed an argument or even been in an argument, the big issues get lost in some small detail. As a mediator, you need to identify the way in which people might act in different circumstances and try to develop a technique for dealing with that. I would create a list for yourself, perhaps a personal list, that you can just keep handy and refer to whilst you're in the middle of trying to resolve disputes for people. And sometimes if you call it, it helps. So if even in a private session, you say, I'm sensing a great deal of distrust, and I think as a result of that distrust, you're trying to avoid the issues and you're not listening. Now, you've got to be very careful about making direct statements to people because you may alienate them. But sometimes if you've developed a rapport, they're willing to listen and acknowledge what you say, and sometimes say, I think you're right. And then you're well on the way to creating an environment where people may be willing to resolve the issues of concern. So understanding what people do in a conflict situation is helpful. You know, sometimes people, they revel in the pain. I know it seems odd. If you like, it's the martyr syndrome, and we see that sometimes. You know, it's sort of a fatalistic, well, there's nothing we can do about it, so what's the point in even talking? You know, I'm suffering, but, you know, it's just the way it's going to be. So your role is to try to generate options in a positive way so that you can work with them in working on a resolution. Remember, of course, it's still their dispute. There are a number of other factors. Craig identified personalities. Nicholas said cultural issues. Monique agreed with that. These are all important things. You need to identify these and have a game plan. Health might be an issue. Financial matters is often an issue. Lack of expertise. People look at things in a different way. And a very common one is that people focus on the negative rather than the positive. And of course, that's part of our reframing technique. All right, any questions then about negotiation in the context of conflict? Why people are in conflict and how they might act in a conflict situation. What I invite you to do is to create a list for yourself in relation to these issues so that you've got a quick reference, and from that quick list, if you like, in a real life situation, you can try to identify how the people are responding and deal with it accordingly. I guess in some ways it's quite intuitive. But there are other factors. People might have time constraints as well, and certainly different goals is a very common one also.
John, just
Yes,
in your
Nicholas?
experience,
Mm-hmm.
how do you define the difference between someone who is saying that they're listening, but they are not actively listening? Because you can talk to someone, they say, yeah, I'm listening, I hear you, but they're not actively listening to what's being said. So how do you define this?
Yes, that's a really good point, because one way is using summarising techniques, but in reverse, and to invite them to summarise the position and of the other side, or more importantly, to summarise the interests of the other side. So if you suspect very strongly that people are not actively listening, you can test them in that sense, very quietly, very subtly, and say something to the effect, now I understand that you want to resolve this issue. Resolution is important to you. It's also important, I sense, to the other side. Would you agree with that? Yes, you've been listening very carefully to what they say? Yes. Well, what do you think are the two or three main issues of concern to the other side? And that will start to test whether in fact they have been actively listening. If they get it wrong, then gently move them around to a situation where you can encourage them to listen more carefully. I hope that answers your question, Nicholas.
Yeah, it does. Hopefully it'll help with some of the teenagers I work with too, mate.
Oh, okay. Yes, teenagers. That's a tough one. All right, so just now moving on to a slightly different topic. As we've been discussing, the role of an ADR practitioner generally is to encourage the parties to retain ownership of the dispute, as opposed to litigation. Litigation has always run on an adversarial basis, or typically run on an adversarial basis in Australian jurisdictions. It has never traditionally focused on ADR. That's changing in civil disputes and even in criminal disputes, as we mentioned earlier. There is now an increasing emphasis on ADR, mostly in civil disputes. And indeed, many jurisdictions now call upon litigants and lawyers to ensure that they have genuinely attempted to resolve issues. Under the federal sphere, if a lawyer fails to appropriately deal with issues and promote ADR, then they may in fact find themselves the subject of an adverse costs order. So it can be very important for the lawyer to be aware of ADR, the processes, and the importance and the relevant factors in it. Okay, you've all read material about negotiation, and I'd recommend that if you haven't, that you read your text, Spencer, in that regard. I'm just going to run through some of the important parts that I think are relevant to negotiation. So in his book, Spencer talks about the writing of Anstey. Anstey identifies 7 attributes of negotiation. It involves more than one party, involves a joint agreement on the outcome, requires movement of the parties' positions and interests. It usually empowers its users to provide self-determination. It's non-interventionary, it's often less expensive, and it allows the parties to control the process. Now, the reason I'm mentioning that is that you'll recall in your text that there are the 14 different types of ADR that we encompass during this unit. That's on page, I think, 3 of your textbook. And you'll recall that negotiation is way at the end of one of the parameters, as opposed to, say, arbitration, which is the most interventionist. So when you're advising a client in terms of the best form of ADR, it may be that simple, good old-fashioned negotiation is the way to go. But because there is a focus now, from a lawyer's perspective, on ensuring that you have adequately dealt with ADR options and you've promoted ADR for your clients, I think you need to formalise it a bit. And that means you need to come up with a list of ADR options that may be relevant in a particular dispute scenario. You need to identify in some manner the advantages and disadvantages of those different types of different types of ADR platforms, and then make a conscious decision as to which one you're going to promote for your client. Part of that is to answer any questions that might be asked of you, particularly if there's the risk of an adverse costs order, as to what genuine steps did you take to deal with this matter in terms of ADR. So you might say negotiation was the platform that was selected for these reasons. And to do that, you need to understand what negotiation's about and have some evidence to back up the fact that you promoted that as the right way to go. I mean, it's a bit like a civil litigation opinion provided to a party where you say, I don't think that court intervention is the right way to go. I think the appropriate course of action for you is self-help. And negotiation's a little bit like self-help is to litigation. Negotiation is to ADR. It's, if you like, the most common, the most obvious, the most non-legal type of technique that's used, but it's there as an appropriate form of ADR, and there are some advantages to negotiation, and I think it's important that you identify those in a slightly more formal manner than traditionally lawyers have done in the past. So I've mentioned that there are 7 attributes. Spencer identifies some advantages of negotiation in his text, and if you think about it, you can formalise the process a little more by trying to identify an attribute with the advantage. So the parties, this is what Spencer says, in negotiation, the parties are in the best position to assess the impact of any proposed solution. Well, that's attribute number 4. Parties own the process, can define the terms in any way they choose, which is attribute 7. Parties create their own solutions, that's attribute 2, and so on. So when I'm talking, what I'm trying to say is, don't just take negotiation as and give it lip service. Don't. You need to promote it and formalize it as a formal ADR technique, and be able to have some justification as to why you chose that platform as the recommended platform for your client. Now, of course, negotiation can work in conjunction with others. And clearly, when we're mediating, when we're conciliating, when we're doing other forms of ADR, we are always negotiating. But I'm really talking about negotiation as a standalone ADR technique. Now, you can formalize it in terms of its attributes, which is really talking about its advantages and disadvantages, or you can talk about the negotiation process and formalize it in that manner. So what are the processes involved in negotiation? Well, you need to undertake some preparatory steps determine the mode of communication, and try to remain consistent in that mode, whether it's by telephone, face-to-face, email, through some form of audio-visual, through office, through a third party, etc. Identify the issues, very common to mediation. Try to develop options, consider alternatives. So these are all things that you can try to formalise with your client if you decide that you're going to try and resolve this issue through negotiation. Now, lawyers have a very important part to play, of course, in that their job is to always try to focus on the client's best interests and what will serve the client best. One of the problems is that clients don't always act in their own best interests. Now, that might surprise you, but sometimes they're just really almost hell-bent on self-destruction. And part of your role is to negotiate using interests rather than positions as the basis upon which the negotiations will continue. Now, you've read in the textbook that there are 4 types of negotiation: adversarial, integrative, distributive, and principled. Quick poll: if you were advancing negotiation to a client as the appropriate form of ADR to deal with their particular conflict, which of those 4 would you promote generally as being the best form of negotiation? That's if you had to formalise it. You're in front of a judge now explaining that you selected negotiation, and the judge, who knows something about ADR, says, what model of negotiation did you use? Which one would you generally use? I'm testing to see if you've been doing your reading here.
Well,
yes,
I did one where I had both facilitative and transformative.
More in the context of mediation, those terms. But I'm looking for something a little different. And I'll just go through the 4 again. So the 4 models of negotiation: adversarial, integrative, distributive, or principled. So we're just going to cast your votes for one of those 4. So we're getting some votes coming in already on the chat facility. Which is the one that you would generally go for? And here are the votes so far. Amanda says principled, Chris principled, Nicholas principled, B says principled, and I've got to say that's the one I like. Did I give it away in my voice to some degree? I'm not sure. I don't think so. So generally principled negotiations. I mean, who's the star of the show when it comes to principled negotiations, do you think? Thinking about some of the movies that we've suggested that you might watch through this unit and other units like evidence and proof. So 12 Angry Men, juror number 8 was the star of principled negotiations. So adversarial negotiation has its place. It's not very creative. It can advantage the party with the greatest resources. So if your client is well resourced, then maybe adversarial negotiation is the way to go. It's offer, it's counter offer. It's a little bit like buying real estate, generally speaking. So it's, you know, one or the other. But one of the problems with adversarial litigation is that it's not particularly creative. So there's a great story, the Orange story. Has anyone come across the Orange story? And it's from Yuri, getting to yes, negotiating agreement without giving in. So the Orange story is, who does anyone remember the story? Want to tell us what it is? Yes, B?
Well, there's one orange, but, you know, actually one sister wanted the zest and the other wanted the juice. So they could actually both have gotten what they wanted. Instead, they ended up like getting half an orange.
Yep, exactly. That's exactly it. And that's one of the problems with adversarial negotiation, It's not particularly creative. And thank you, B. They could have got 100% of what they wanted, but they both ended up with 50%. Integrative negotiation is linear. It's very similar. And it's just talking about a pool of resources that has to be distributed. But integrative does have the opportunity to increase the pool of resources available by value adding. So it's a little less linear, but it is providing some other form of resource or option into the equation. Distributive is a little bit where if one loses, the other will gain by the corresponding percentage. So it's like adversarial in that there's a zero-sum transaction producing a win or loss. But the one that I'd really like you to focus on, generally speaking, is principled negotiations, as you've identified. And the principled negotiations mean that you are essentially negotiating from positions, the interests rather than positions. So people usually start negotiations from their own position, whereas what you want to try to do, like in a mediation situation, is negotiate, if you can, around interests. So, and I guess the basic question might be this. If you said to someone, what do you want? They'll probably tell you something that relates to their position. If you start to ask questions about why do you want this, you're then starting to ask questions about their interests. So it's very similar to a mediation session. And I think in being trained in ADR practice and applying it, you'll start to use this as part of your interview technique a little more often, and perhaps generally as well. So when you're involved in principled negotiations, you'll find yourself doing things that would not be typical in adversarial negotiation. You'll start to think about options. You'll brainstorm. You'll make a conscious effort with your client to think about matters from the other's perspective. And you'll think about what happens if the matter is not resolved. So the best alternative to a negotiated agreement, the worst alternative to a negotiated agreement. So all of those things that we do in mediation, in many ways are transferable to the way in which you go about undertaking principled negotiations. It all starts with the way in which you approach your client, the way in which you ask the questions, and the way in which you ultimately frame offers to the other side. Okay, so just bear in mind that I'm asking you to consider this in a more formal manner than you might otherwise do from the way you've always done it or what you think negotiation might be. So try to formalize it. And bear in mind that if you go into a negotiation with a principled negotiation in mind, you give yourself a better chance of resolving the issue, I think, than if it was some other form of negotiation. And the reason I say that is that you're able to generate more options. And if the other party is looking like withdrawing and going to litigate, if you've got more options available, it means that you can hang in there and try to resolve the matter more readily. I mean, bear in mind, people don't like to make decisions. They're emotional. People avoid conflict. So you've got to try to encourage your client to embrace these things and encourage positive discussions and overcome some of the issues that hold people back. Okay, so that's all I want to talk about in the context of negotiations. That's a brief overview. Any questions, comments? All right. Just finalising matters on mediations. We've talked about a lot of the practical aspects. I'd like you to do some research in addition to the material, and that is to have a good look at the website for the Mediator Standards Board, MSB. So MSB Australia is responsible for the implementation of the National Mediator Accreditation System And that system, which is on the website, provides some important information. In particular, it provides information about practice standards to nationally accredited mediators. So I'm one of those, and like others that are accredited nationally, you have certain additional obligations. Now, I haven't been through these, so I didn't talk about them. Thank you, Nicholas. The msb.org.au, and Jackie is as well. So, Jackie, be aware, with the accreditation comes a little bit of extra responsibility, and the way to look at this is to look at the practice standards. Now, the reason I'm suggesting you do this is it's a very good way of checklisting the way you go about your practice as a mediator. And now we're starting to talk about some of the law that goes with the ADR practice. So by looking at the national, Mediation Standards Board material and the practice standards, you're starting to think about some of the responsibilities that go with being a mediator and formalise the situation a bit more. So, for example, and these are just examples, find the practice standards, have a look at paragraph 2.2, which describes the process of mediation, and try to understand the difference between, if you like, a facilitative mediation and what the practice standards call a blended process, which is really where it's an advisory aspect comes in. So look at 2.2 and start to use some of the terminology. And very importantly, if in the take-home examination there's a question that deals with mediation, then you must refer to the Standards Board, and you must refer to the practice standards, because it's like a benchmark. Whether you're accredited nationally or not, you should still be aware of those standards. Have a look at clause 9.1 in the practice standards, and it says that a mediator must respect agreed confidentiality arrangements relating to participants and information, and it provides obligations on a mediator to preserve documents, to maintain confidentiality, and to ensure that the process is undertaken fairly. The other thing is that in these standards there are certain responsibilities that must be stated to the participants. For example, that they may have an opportunity to lodge a complaint or provide feedback, and that must be provided during the intake or in the preliminary comments by a nationally accredited mediator. Okay, wow, someone's been typing a lot of material. So, Nicholas. Okay, oh, you've just cut and paste. Is that what you've done there, Nicholas?
Yeah, it didn't paste too well though, but that's 9.1.
Thank you. I just thought you were an incredibly fast typist there for a moment. So thank you. So the lesson from that is just to wrap up mediation work, to please have a look at those national standards and the practice standards from the Mediator Standards Board. Jackie, is there anything you wanted to add from that discussion?
No, I don't think so. But just, yeah, just to mirror what you say, obviously, when you are an accredited mediator, you do have to work under certain guidelines and be aware of those.
Thank you. Great. Thanks, Jackie. All right. So any questions then on mediations before we move on to our discussion on conciliation? All good? And you're all being very patient. Thank you. All right. So conciliation, have a look at definitions. A good place to look for any definitions when it comes to ADR practice is to refer to NADRAC. It's now no longer operative, but still carries with it a great deal of weight. So that's the National Alternative Dispute Resolution Advisory Council, NADRAC. So when you look at the definition of conciliation, you'll see that in many ways it's like mediation, but it carries with it a formalised advisory role. It doesn't mean the conciliator must give advice, but it means that the conciliator has this opportunity, this advisory role, to talk about the content of the dispute or the outcome of the dispute, but still within the context of not being a decision maker. And that is important. So if you're doing a conciliation, you still need to ensure that the parties are aware that you're not making a decision. They should not confuse any advice or comments that you make with you being a decision maker. And of course, if the matter does not resolve, you cannot be, you certainly should not be the decision maker. For that, I would make it an absolute rule not to be the decision maker. So again, have a look at NADRAC. If you want a definition of conciliation, I think that's the best, most authoritative source, but there are a number of sources available to you. And in an exam or take-home exam situation, you would need, in the context of conciliation, you'd certainly have to refer to NADRAC somewhere or another. Any questions about conciliation, how it differs from mediation, the meaning of it, the role of the conciliator versus the role of the mediator? We often see conciliations within the context of some decision-making body. So, Jackie, I imagine you do conciliations.
I actually do both.
Right.
But different jurisdictions.
Okay.
So when it's unfair dismissals, it's conciliation, and I absolutely get more involved in talking about strengths and weaknesses of the case and likely outcomes or potential outcomes. But when I do anti-bullying, that's a mediation process, purely around interests and options and solution or resolution generation. It's a different process.
Great.
Yeah.
No, thank you. Thank you, Jackie. I appreciate that. And likewise, say, in the Queensland Civil and Administrative Tribunal, someone like me might do conciliations in a building dispute, for example, so that you have more an opportunity to roll up your sleeves. Another thing which is common to conciliation is if you're annexed to a decision-making body and you have power conferred on you, can actually make orders as a result of the conciliation as well. Okay, but again, the same principles apply. In a conciliation, you're there to assist the parties. You want them to retain ownership of the dispute. You're not there as a decision maker. The dispute remains confidential. You're there to consider options, to generate alternatives, but then provide advice, provide some professional expertise, and maybe provide some more direction than would otherwise be the case in a mediation. And the higher level of conciliator intervention is usually involved in something which is annexed to a court. So it's just taking it another step or two in one direction. Again, with a conciliator, you're looking for the parties to come up with their own agreement. The conciliator may be potentially more involved in the process of documenting that dispute, or in some instances actually providing a consent order to reflect the agreement that has been made during the conciliation. Have a look at there's an article, "And the Leopard Shall Lie Down with a Kid, Conciliation Model for Workplace Disputes," David Bryson, and I think that is in the material. So in that, David Bryson says, in relation to conciliation, it contains some or all of the following elements: settlement of dispute as expeditiously as possible, administrative review of decisions, identification of systematic issues resolving, giving rise to the dispute, facilitation of mutually acceptable agreements, power to issue recommendations or make directions, and an assessment of the parties' genuine attempts. So in summary, and I know I'm moving quickly, but please supplement these words with your own reading. The distinction between mediation and conciliation, to be honest, can be unclear. And where we have advisory mediation, it looks very much like conciliation. So there is a grey area. There is, as you've seen, a considerable degree of overlap, but the main point is that in either case, mediators or conciliators do not have a determinative role. Generally, the terms are not used interchangeably, but the concepts are in many ways. Jackie has said that in her organisation, her style, she keeps them quite separate, and they are dealt with from a different mindset. I'm much the same, but sometimes it looks similar from the outside. I hope that makes sense. All right, have a look at the Access to Justice Task Force. There's a report in 2009 that led to the Civil Dispute Resolution Act 2011, which is Commonwealth, and a cornerstone of that piece of legislation is that litigants must take genuine steps to resolve disputes before commencing proceedings in the Federal Court or the Federal Circuit Court. And there are instances of where that is relevant in other pieces of legislation and other jurisdictions. Well, I think that might do us for tonight. Thank you again for your patience. Are there any questions? All right, so what I'd like you to do is keep your reading up to date. And I know we're a little behind in terms of the weekly tasks, but you should certainly be reading up to and including conciliation work and looking at some of the legal aspects of it. But at the same time, think about those practical skills that we've been discussing. Right, any questions, comments? All good? Okay. All right, well, thanks. We'll end the session for tonight and we'll see you all next week. Okay, bye then.